Hello, everyone. My colleague and I, Gabrielle Negro, are very pleased to share some of the recent Occupiers Liability Act claim decisions. And my name is Alison Presse. We are part of a firm called SBA Lawyers. So our focus today will be on slip and falls and the defendant's winter maintenance systems. This presentation will be recorded and on our website should anyone wish to review or share. If you have any questions throughout, please feel free to put them in the chat and we'll connect with you after the presentation. So as most of you, I'm sure know, the Occupiers Liability Act is the statute that governs all slip and fall claims. We'll be referring to it as the OLA throughout the presentation. The OLA establishes the duty of care on occupiers of a premises. Section 3.1 of the OLA states that an occupier owes a duty to take such care as in all the circumstances of the case that is reasonable to see that persons entering on the premises are reasonably safe while on the premises. All the cases we're going to be discussing today will demonstrate how the courts define what is reasonable and what goes into the determination. I'll start with a very recent case, a 2024 decision of Justice Henderson of the Ontario Superior Court. This case is called Ranger versus Triovest Realty Advisors. This action was brought by the plaintiff following a slip and fall while crossing a crosswalk near the entrance to a Walmart store. It occurred in Sudbury, and there had been freezing rain before the accident. The plaintiff noticed that the parking lot was slightly slippery. She walked cautiously and she wore winter boots. Triovest Realty Advisors managed the premises, and the co-defendant Pioneer Construction were contracted to do the winter maintenance. So in this case, the plaintiff argued that the defendants breached their duty under the OLA by failing to implement an effective winter maintenance system. Specifically, that the system of maintenance lacked proper inspection and monitoring of the crosswalk for ice or snow. They also argued that the agreement between Triovest and Pioneer contained unclear monitoring responsibilities, and also that Triovest did not adequately oversee Pioneer's work. So when we look to the facts and the evidence as to what the defendant had in place and what occurred, we see that there were no clear triggers in their winter maintenance system or in their contract for freezing rain, only for snowfall. We see that the crosswalk was not given proper priority. It was simply plowed like the rest of the areas, despite more frequency of use. Their system of maintenance did not include consideration of the nature or frequency of monitoring or inspection. So although there was some ad hoc monitoring of the property, the efforts were casual, they were inconsistent and not well defined. In their testimony, the defendants were unable to explain their obligations as it related to frequency. And finally, the record keeping was found to be inadequate. So ultimately, with all of this, the court's decision was that the winter maintenance system was inadequate. It was lacking clear provisions for inspection and monitoring the property, especially in high traffic areas like the crosswalk where the plaintiff was, where the incident occurred. The defendants, so both Triovest and Pioneer, they were found collectively liable for the plaintiff's damages. He also looked into whether there was any contributory negligence on the plaintiff in this case. The defendants argued that the plaintiff may have been in a hurry when she crossed the crosswalk because a driver had motioned for her to proceed, and also that the plaintiff should have been looking at the ground while she was walking. Ultimately, the court found no contributory negligence. There was no evidence to show that the plaintiff was in a hurry. She testified that she was aware of the slippery conditions and was walking cautiously. And it was unreasonable to expect the plaintiff to focus on the ground while crossing the roadway, as she had to watch for vehicles. It was in the parking lot. She also wore appropriate winter boots. She walked carefully, and she used a crosswalk. So the takeaways from this case, Ranger and Triovest, that the winter system of maintenance may need to prioritize necessary. So in this case, it was the crosswalk. Also, a maintenance system needs to account for all types of precipitation and all types of weather. So in this case, that was freezing rain, which the winter maintenance system did not speak to. And finally, with respect to contributory negligence, it's difficult to attract. You need to show more than a likelihood of rushing or that a plaintiff should be staring at a ground, especially in this case when she's crossing a crosswalk and really should be looking for vehicles. So I'm going to move on to my next case that I'll be discussing, and it involves another slip and fall on ice. The defendants brought a summary judgment motion arguing that there was no genuine issue requiring trial on the issue of the alleged breach of duty under Section 3 of the OLA. So this case is Chambers versus Remnant Tabernacle Church. It was a 2022 decision. I can say that I did a little bit of work on this matter and in fact actually attended at the incident scene and got to meet the pastor and some of the employees of the church. So I'm quite familiar with it. A bit of a background on the facts of this matter. The fall occurred in the church parking lot after a recent winter ice storm. The plaintiff attended at the church that morning. She was attending a service, and upon arrival, she and other parishioners noticed that the parking lot was ice covered. So they began salting the parking lot. This was fairly normal for parishioners to help out and volunteer and do some of the winter maintenance activities. She also decided to block the parking lot with her vehicle so that other people wouldn't enter with their vehicles and potentially slip and slide on the icy parking lot. However, since there was nowhere for anyone to park, when the pastor arrived at the church, he asked the plaintiff to move her vehicle so that people actually could go into the parking lot and park their vehicles. It was after parking her car and crossing back over the lot that she slipped and injured herself. For this summary judgment motion, the church argued that it had a reasonable system of maintenance in place and that they took steps to ensure the property was reasonably safe for visitors. The church further argued on section 4.1 of the OLA, which stipulates that a party is absolved of liability if someone willingly took a risk. So the church stated that it was known to the plaintiff that when she ventured across the parking lot, she was taking a risk and she could fall and injure herself. So the question for everyone today is, was summary judgment granted? And we actually have a poll. So it's just a yes or no question. You can take a guess. I'll give you 20 seconds or so to put in yes or no. Okay, so the results are in. Looks like most people thought no. And the answer is on the next slide. No, you're correct. It was not granted. So in making its decision, the court took the following into consideration. It was agreed it was dangerous, so everyone agreed it was icy and quite treacherous in the parking lot. It was also agreed that the church had run out of salt and had only been able to acquire 3 bags the day prior. And it was established from the custodian that it would normally take about 8 bags to treat the entire surface. The church had knowledge also of the icing conditions before the fall, at least the morning of. They were aware that this was a dangerous area. And the church custodian and its volunteers salted as needed, but there was no formal training or instructions. They're made to use common sense when doing the winter maintenance. There was nothing in writing with respect to winter maintenance program. And although there was a shortage of salt, which was established, there was no consideration to sand or break ice or do anything else due to the lack of salt. So the court decided that the plaintiff raised a genuine issue requiring a trial to determine whether the church met its obligations under Section 3.1 of the OLA. the court decided that the evidentiary record was unclear and conflicting in some areas, such as whether there was a winter maintenance system in place for this weather, what role the parishioners were to play, who was directed to move the plaintiff's vehicle, amongst other things. When considering Section 4, the arguments regarding Section 4 of the OLA, whether the plaintiff was willingly assumed the risk, the court quoted the Supreme Court of Canada decision in Waldick versus Sundance Northwest Resorts, and I'll just read it to you here, just a sentence. Rare may be the case where a visitor who enters on a premises will fully know of and accept the risks resulting from the occupier's non-compliance with the statute. So the court did not find that the plaintiff, by walking over the area once or twice and attempting to help salt, willingly assumed a risk to be injured that day. So as stated before, the summary judgment motion was dismissed. The takeaways from this case are that despite the church being a not-for-profit, which was an argument kind of pushed and put forward by the defendant, by the church, you still need a proper system of maintenance in place, and of course followed. And even volunteers, despite not being employees, may need some type of training or some type of instruction. Further, even if there is a community shortage of salt, you need to look to other options, whether that's sanding, breaking ice, or closing or canceling a service. So if there's advance notice of an issue with safety, such as in this case, they were aware that the parking lot was dangerous and icy, they need to do something more to address that safety concern, such as sanding or, again, even closing the church. So thanks, everyone. I'm going to pass it on to my colleague to discuss a couple other cases.
Good morning, everybody. Thank you, Allison. As Allison mentioned, my name is Gabrielle, and I'm an associate here at SBA. And the first case that I'm going to be talking to you about today is a 2023 Court of Appeal decision by the name of Musa and Carlton Condominium Corporation. This case deals with a snowstorm that happened in Ottawa. The year is 2016. It's the first snowstorm of the year, and it happens at 4 o'clock in the morning. And the condominium had contracted out its winter maintenance to a snow removal contractor, Exact Post. And Mr. Newman, who was an operator for Exact Post, arrived at the plaintiff's condominium at 7:30 that morning to plow and clear the snow. At 8:34 that morning, Mr. Newman phoned Mr. Mitchell, who was the owner of Exact Post, to let him know that he had almost finished plowing and that the premises were ready to be salted. And when Mr. Newman finished, he did not apply any road salt on the roadway, despite the fact that there was a box of salt available that could have been applied with a shovel, because he believed it was not part of his job. So Mr. Mitchell, the owner of Exact Post, was personally responsible for salting all 14 properties that Exact Post was contracted to, and he arrived at the premises at 10 a.m. And of course, it's literally Murphy's Law. At 9:30, in the time between Mr. Newman phoning Mr. Mitchell and Mr. Mitchell arriving to salt the premises, the plaintiff slips and falls on the unsalted roadway. So the trial proceeded on the issue of liability alone, focusing on whether Exact Post met the reasonable standard of care required for commercial snow removal contractors in the circumstances. And the main question before the court at trial was whether the delay in applying road salt by Exact Post, which wasn't done until almost hours after the plaintiff's fall, was reasonable in the circumstances. And the trial judge found that Exact Post's failure to apply the road salt promptly, either concurrently with or immediately after plowing the snow, constituted negligence. And the trial judge found that the roadway required immediate salting after plowing to prevent ice formation, and that the delay in salting is essentially what contributed to the plaintiff's injury. So ultimately, the trial judge determined that the delayed application of salt was below the standard of care required of a commercial winter maintenance contractor in the circumstances, and that this negligence directly caused the dangerous conditions leading to the plaintiff's fall. Well, Exact Post appealed the decision, and they appealed on three grounds. The first ground that they argued was that the trial judge misapplied the reasonableness standard of care by finding that Exact Post should have arrived at the premises at 6 a.m. Exact Post noted that its contract stated it works between 6 a.m. and 11 p.m., and that it would be impossible to simultaneously attend all of their clients' properties at 6 a.m. But the Court of Appeal clarified that the trial judge only made general reference to 6 a.m. as a time when Exact Post could have reasonably attended the premises. The Court of Appeal held that in light of the snowstorm starting at 4 a.m. and the decision not to pre-salt, it was reasonable to expect Exact to start salting earlier to address the icy conditions before the morning rush. Next, Exact argued that the trial judge misapprehended the evidence and failed to consider their contractual obligations. In this argument, Exact had said that the contractor was only required to complete plowing after the entire property or plowing the entire property before applying salt. But the Court of Appeal said that the fact that the maintenance contract stipulated this was completely irrelevant to Exact Post's duty of care. And the Court of Appeal cited the good old case of Donahue and Stevenson for the principle that the duty to take reasonable care exists independently of any contractual obligation. Finally, Exact argued that the trial judge failed to look at the spectrum of characteristics set out in the 1991 Supreme Court of Canada decision of Waldick and Malcolm in his standard of care analysis. And very quickly, these principles include things like weather condition, time of year, property size, cost for preventative measures, footwear quality, and the length of the pathway. But pretty simply put, the Court of Appeal found that the trial judge had correctly applied these principles. So ultimately, the appeal was dismissed, and the plaintiff was awarded almost $20,000 in costs for this appeal. I should also note that Exact Post then sought leave to appeal to the Supreme Court of Canada. They just didn't give up, but that was dismissed earlier this year. So a quick takeaway from this one, I think there's an obvious one, which is that areas should be salted concurrently during the plowing process itself or immediately after. But more importantly, I think the main thing with this one is that it doesn't matter what your contract says, the duty to take reasonable care will exist independently of any contractual obligation. So the last case I'm going to talk about is Karake versus the Numbered Company. This is another liability only trial. So this fall occurs on a snowy day in December. The plaintiff finishes her workday. She goes to a party supply store sometime between 3:30 and 4 p.m. and she parks her vehicle in a parking lot near the side of the store. And from the side parking lot, there's a little sidewalk that leads to the front of the store. And the plaintiff walks from her vehicle to the front of the store and admits that this walk that she takes isn't icy. And as she's walking on the sidewalk, an employee from the store is salting the sidewalk near the front door. The plaintiff spends an hour and a half inside this party store, which is crazy in and of itself. And by the time she exits, it's now sometime between 4:30 and 5. And as you can imagine, like any December day, it's now completely pitch black. And it was also a lot snowier than from when she originally went into the store. So the plaintiff figures, okay, I'll leave my shopping cart at the store entrance and I'll walk over to my vehicle with the intention of driving it closer to the store so I can load all my purchases since it's dark outside and there's a lot more snow. And the plaintiff once again admits that the sidewalk running along the front of the store was salted and it wasn't icy. She then drives her vehicle from the front of the store and walks to the rear of her vehicle to open the trunk. And then she takes a step up to the store, and of course, she slips on the first step. And she admits at trial that she wasn't on the lookout for hazards or slippery things on the stairs because she trusted that everybody was doing what they were supposed to. And after the incident, the plaintiff's son and husband attend the store and take photos and a brief video of the incident area. And honestly, it's not looking good because there was no salt in these photos. So, the defendant, Bayview Summit Developments, was the landlord of the property and responsible for winter maintenance of the sidewalk abutting the store and the interior concrete stairs or exterior concrete staircase. And an employee of Bayview advised that during the winter weather, he would shovel snow from and apply salt to the concrete walkways and the stairs near the store. And the maintenance logs showed that on the date of loss, the property was maintained between 9:56 a.m. and 10:15 a.m. And although not shown on Bayview's maintenance logs, evidence was provided that there was a second attendance at 2 p.m., during which time the sidewalks and the steps were resalted. However, Bayview's employee wasn't actually able to confirm how much salt had been used on the date of loss. And in addition to this winter maintenance, the co-defendant and owner of the party supply store kept a bucket of salt available in the store, and employees would salt the stairs and the walkway whenever they felt it was necessary. The store owner gave evidence that during a winter storm, store employees would check the condition of the walkway and the steps at least hourly. And it was the store owner's evidence that on the date of loss, their employee salted the area hourly, with salt having been applied at least 5 times that day. And that person advised that the last time that they salted the area was at about 4:50 p.m. So we have another little poll. Based on what you've heard, do you think that the court agreed that the defendant's winter maintenance system was sufficient? And again, we'll give you guys like 15, 20 seconds to vote. Okay. Ooh, it's pretty much a 50-50 split. Um, so the answer is no. So the court considered the obligations of an occupier under the OLA and determined that the defendant's system of inspection, maintenance, and monitoring of the condition of the steps were insufficient. The Bayview maintenance log did not capture the frequency of salting the steps, which was an issue in this case. And while Bayview relied on the evidence that the party supply store employees maintained the area throughout the day, the court noted that the store's maintenance records didn't have any entry past 11:07 a.m. So there weren't any contemporaneous records to the evidence that the salting and inspection had taken place around the time of loss. Those photographs taken by the plaintiff's son definitely did not help the defendants because, you know, as we mentioned, the defendant said that the steps were last salted at 4:50 p.m., but she fell sometime between 4:30 and 5, and there was no salting in those photos. So on the basis of all the evidence, the defendants were held 75% liable for the loss, and the plaintiff was found 25% contributorily negligent for failing to look for ice despite the weather conditions, and also not holding on to an available handrail while mounting the steps. So the major takeaway from this one is make sure that you have detailed logs and an adequate system of inspection. So to wrap it up, just wanted to give, takeaways from all the cases. There's obviously a major theme here, which is, like I just said, proper system of maintenance and inspection. And again, up to date detailed logs are super important that you're asking for that right away. And next thing is that you can't rely on your contract to shield you from the duty of care as an occupier. Um, Third, a system of maintenance may need to prioritize certain areas if necessary. And that system should also account for all types of weather, such as freezing rain. And like we saw in Allison's second case, even with charities and nonprofits, you still need to have a proper maintenance system in place, and you still need proper instruction and training, even for volunteers. And finally, if there is advance notice of a safety concern, such as a shortage of safety supplies or equipment, or there's a hazardous area that's being brought to your attention, you need to be doing something more. Thank you guys. And like we said, if you guys have any questions, please pop them in the chat. We're happy to answer after the presentation.
Thanks so much.